NLADA is proud to host the 2025 Beacon of Justice Awards, celebrating law firms that demonstrate a profound commitment to equal justice through innovative and impactful pro bono work. This year's theme, Sustaining Equal Justice for Families and Communities, highlights efforts to strengthen the legal framework and support systems that uphold families and empower communities across the nation. Congratulations to all of this year's winning firms.
Our last mass evangelism campaign that we had in November had 250,000 people come. The government seemingly got really nervous over that many people gathered together, and they feared someone would maybe utilize that to coalesce a political movement to be a threat to their power. They arrested all of our people in December of 2023. 11 of our pastors and leaders and two of our Nicaraguan lawyers.
They put them and a host of other people in prison for nothing more than engaging in religious freedom.
Freedom's a threat to tyranny.
I received a text message from a dear friend in Austin, Texas, and he told me that the leader of Mountain Gateway, Britt Hancock, was in Washington at the time and wanted to know if we would be willing to sit down with Britt and see if we could be helpful as a law firm. When
we moved to Washington, we knew no one, and nor did we know how really Washington worked. We were kind of lost. And so a friend of mine connected us with some senior partners at Aiken, and then they just volunteered to help and were invaluable to us, and was really, for us, an extraordinary experience.
The thing that really stuck with me when we began to engage with the U.S. government to try to understand whether there were some pressure points that could be sought in order to secure the release of these individuals. One high-level State Department official said to me, Ryan, you don't understand. This is essentially North Korea of Central America. There aren't any pressure points.
Yeah, this was a unique challenge because there was no clear roadmap of where to go. And we had to figure out from the very beginning, how can we get all of our resources consolidated to try to come up with a solution.
They had ordered the arrests of the Mountain Gateway pastors alongside 4 American citizens. There were efforts to try to keep them outside of Nicaragua through the abuse of the Interpol Red Notice system.
We believe the Nicaraguan government did that to terrorize the Mountain Gateway leadership and to try to hurt the organization as much as possible in that way. We started an effort to engage with the Department of Justice, with Interpol itself, and with the Congress to try to find a solution to have these notices reversed and taken out of the system.
At the end of the day, the Nicaraguan government was going to do what it was going to do, and the only way they were going to be stopped and change course would be if the American government intervened. And in the end, I think we were the perfect firm to get involved because we brought all aspects of our Washington practice together.
In September 24, they were finally released, boarded onto a plane, flown out of the country, and then more hard work continued.
Once they were released, the next big question was, how are we going to get them all to the United States? And there were 2 options on the table. There was humanitarian parole and refugee resettlement. Everyone agreed that refugee resettlement would be the better option because it did offer a path to citizenship.
This whole matter, from start to finish, brought together so many different parts of this firm. We were able to pull all of that together and collaborate in a way that I truly don't think would be possible at any other firm.
The hand of God was really helping us, putting the right people on our team, because we would have been lost for sure without Aiken.
Pro bono is a priority at Beveridge and Diamond. Over half of all B&D attorneys, both principals and associates, participate in the firm's pro bono efforts. B&D undertakes a variety of pro bono work, ranging from amicus briefs on racial justice and the rule of law, immigration and refugee support, to landlord-tenant issues and criminal clemency cases. The firm also supports organizations that engage in projects concerning civil justice reform, such as the Council for Court Excellence.
I think one thing that has been really wonderful about my pro bono experience here is that it doesn't have to be these big monumental cases. We have taken very small cases something, just preserving the dignity and death of somebody who wants to make sure that their property is disposed of in accordance with their wishes, all the way up to a 13th Amendment case against the United States. I think all of our pro bono work really has kind of this human rights, human dignity aspect to it. And we are very fortunate to have relationships that allow us to provide opportunities to our attorneys to help out in ways, I don't even want to say large and small, but with varying time commitments. We're trying to erase the badges of slavery for rightful members of the Muskogee Nation. These people have been guaranteed citizenship by a treaty duly ratified by the United States and the Muskogee Nation. That treaty remains the supreme law of the land as far as we're concerned. And we are seeking to get a court to agree with us and reestablish citizenship for our client and for other descendants of formerly enslaved people. I went to law school being told that very few people get to practice constitutional law. And here I am, practicing constitutional law. Very few people get to bring 13th Amendment claims. Here I am, bringing a 13th Amendment claim. All thanks to the commitment to pro bono that Beveridge and Diamond has made, and to the wonderful clients that I've had a chance to meet and work with, and who have entrusted me and my firm with this extremely important case.
Working with the National Veterans Legal Services Program, Deckard served as pro bono counsel to more than 3,300 Navy and Marine Corps veterans who were unjustly denied military medical retirement benefits for over 15 years.
Having an advocate for veterans is very important because there's so many veterans that they often slip through the cracks. Oftentimes the initial decision maker who is responsible for granting veteran benefits is not a lawyer. As you can imagine, hiring a lawyer can be very expensive and out of reach for many veterans. So being able to receive pro bono representation is tremendously helpful to these veterans.
So we started working with the National Legal Services Veterans Program several years ago. They often initially identify cases that have potential and that are worth pursuing.
After the briefing was completed on the summary judgment motions, the Navy tried to submit a declaration that they wrote after the fact, explaining why they had rated Marines and sailors the way that they had rated them. We were able to get the court to agree that the declaration should not be considered part of the administrative record, to strike it from consideration. We were able to reach agreement that the Navy would reevaluate each of the approximately 3,100 sailors and Marines affected by their improper ratings.
One of our named plaintiffs actually is in that category of people that Chris had mentioned that received a letter in the mail indicating that the Navy had reviewed their record and made a determination that they were actually eligible for medical retirement from the Navy. So that was a wonderful outcome. I think that there's a number of 3,000 plus of veterans who were within this class. Before I joined Deckard, I served in the Navy as a medic for a period of 6 years. I felt after law school and after I joined Deckard that I had ability to continue giving back to that community.
Hearing that individuals are affected and seeing their face through the document discovery and getting to know their names, their backgrounds, putting a face to the name and then seeing that name have a positive outcome warms your heart first and foremost, but also just it feels like you've accomplished something.
So I'm just grateful to the firm that we have these kinds of great opportunities to not only do good, but actually work on our skills and also learn a little bit more about each other while we're doing it.
My name is Ben Weinberg. I'm the pro bono partner at Denton. On behalf of my firm and my colleagues, thank you so much for the Beacon of Justice recognition. While we obviously don't do pro bono work to be recognized, we are grateful that NLADA has chosen to recognize our work on behalf of domestic violence survivors in our Order of Protection Appeals project that we have led along with Legal Aid Chicago for 13 years. At the same time, we would like to make it very clear that our pro bono work simply could not exist or thrive without the leadership of NLADA and its members. Earlier this year, I was fortunate enough to attend the NLADA ABA Equal Justice Conference, and let's just say that all of us walked away energized and educated. Finally, we want to thank April Fraser-Kamara and her entire team for leading all of us with the Just Funded campaign, a collaborative effort of the legal community to support and defend funding for legal services and for social justice. Thank you, NLADA.
Hi, I'm Harmony Jones, Pro Bono Counsel at Eversheds Sutherland. We are truly honored to be recognized with the 2025 Beacon of Justice Award. Eversheds Sutherland has a long-standing and strong commitment to pro bono work that increases access to justice, strengthens civil rights protections, and empowers vulnerable populations. Over the last year, we engaged in pro bono work, which addresses some of the pressing legal challenges and systematic inequalities faced by families and communities, working to create lasting change and helping our clients and communities thrive. Some examples of this work include representing immigrant clients and families seeking asylum and protection under the Violence Against Women Act, assisting low-income single mothers in DC and accessing tax credits and guaranteed income, obtaining guardianship for parents with children with severe disabilities as they turn 18, and representing rehabilitated clients seeking a meaningful second chance by advocating for parole after decades of incarceration.
One of our big areas of pro bono practice is immigration, where we assist clients in a wide range of cases, including asylum, special immigration juveniles, and violence against women. One case I'd like to highlight is a case we originally got from KIND, which is Kids in Need of Defense. We began representing a teenager who fled from Guatemala after a gang killed some of his family members, including an uncle who told the police about one of the murders. After we interviewed our teenage client, he told us about his adult sister and his adult uncle, who were also in the United States and needed assistance. We then contacted Catholic Charities to help us with the adults. And last summer, we convinced an ALJ that the uncle should get asylum, and we have a trial coming up this year and next year for other family members. Our work wouldn't be possible without the incredible legal service organizations we partner with, including KIND and Catholic Charities, and also Amica and GAIN. And this work is crucial in our firm's dedication to providing legal services to families in crisis and empowering vulnerable populations.
We also seek to challenge systematic barriers within the criminal justice system. We are committed to representing clients in prison seeking meaningful second chances, working together with the ACLU of Maryland Parole Partnership. We represent clients seeking parole who are serving life sentences, have served at least 30 years in prison, have demonstrated maturity and rehabilitation, and are ready to contribute to our communities. All of our clients were sentenced to life while in their late teens and early 20s. We also find many of our clients did not receive adequate representation, and that racial bias and constitutional errors played an unfortunate role in both their trials and sentencing, often resulting in unreasonably long prison sentences. In 2024, we won parole and release from prison from one of our clients who had been sentenced to life in a Maryland prison. Our client, who served nearly 35 years behind bars, turned his life around through education and serving others in need. He was overjoyed to be free and reunited with his family and friends who greeted him warmly at the prison gates. He has recently been volunteering as a youth mentor in Baltimore City and was reunited with all of his 3 children, 6 grandchildren, and 7 great-grandchildren at a family holiday gathering. Each of our clients has families and communities that benefit from their presence and involvement. Person by person, they are strengthening the fabric of our communities. Thank you so much again. Eversheds Sutherland is honored to receive this recognition.
So I had the opportunity to work on this case with a great team from the SF and LA office, and we were representing an amazing client who had fled a foreign country with her 3 young children and fled really severe abuse by her ex-husband. And her ex-husband had brought a case against her under a treaty called the Hague Convention on International Child Abduction, which allows a co-parent to sue the other co-parent if they allege that the children have been wrongfully removed from their last place of habitual residence. And it allows the suing co-parent to force, if they're successful, force the children to be returned to their last place of habitual residence.
The whole idea with these cases is that while they were meant to prevent international kidnapping, they're often used by abusive spouses to return children to an abusive situation.
The Hague Convention cases move at a really quick pace. We were scheduled to go from the start of the case, when we took over the case, to trial within 10 weeks.
And so everything was happening on a really fast timeline, and we were trying to argue that 1, the foreign country where the family had been living was not their last place of habitual residence. And 2, even if it was, the children shouldn't be forced to return there because of the grave risk that they would face if they were forced to return there to the country where they weren't citizens, they weren't even permanent residents, they didn't speak the language, none of them had any connections there beyond the 4 months that they had spent living there. And so our client was amazing and had kept tons of evidence of the abuse over the years and evidence of the fact that they had never intended to stay in this country more than a very short-term period.
In this case, for example, the petitioner deleted evidence. The petitioner made false statements to the court, and the petitioner had issues with privilege between him and his Armenian attorney. And we kind of saw different pieces of evidence that really undermined and weakened the petitioner's case. And what that led to was approximately a week before trial, petitioner decided to seek an extension of trial. And when that failed, they decided to seek to dismiss the case with prejudice. So the result of the case was that we were able to obtain a dismissal of prejudice, and we also convinced the court to tag on additional protections and conditions for the benefit of our client and the children.
I think Gibson's approach to the case was unique just because of the way we were thinking about it. Obviously, most of us hadn't had experience on Hague Convention cases before, but there are a lot of similarities to the other big civil cases that Gibson is working on. And so I think the things that the team was attuned to, like the potential spoliation risks, like the statements and the false pleadings, were similar to the things that you'd be working on a typical case in Gibson. And I think we had the resources and the time to really, dig into those, and in a way that, if you're paying for private attorneys, I don't think our client necessarily would have been able to.
Gibson's approach to pro bono is different than what I've experienced in the past, which is Gibson allows you to run with it. Essentially, you can, if you come up with a theory or you think that you should explore something, you're generally able to do that. If it makes sense, you can, say, we suggest we do this, we should probably get an expert on this issue, and it tends to happen.
Me and the entire team, we all feel just very grateful to have had the chance to get to know our client. I think beyond just constantly being amazed with how much evidence she had collected, how plugged in she was to the drafting of everything from discovery responses to the pleadings and just the things that she was catching. I think we were all just really in awe of her and how committed she was to building this life for her and her kids. And so I think I at least just feel very grateful that I had the chance to get to know her.
I've been representing parents in pro bono international child abduction cases for years. There is nothing like reuniting a parent with their child. but I've never had a case like the one we've been working on for the past 3 years, representing the young Afghan couple who are refugees who've been granted asylum in their efforts to regain custody of their daughter who was taken from them by a United States Marine who was able to use his connections and his status to fraudulently obtain an adoption order for her while she and our clients were in Afghanistan. That has been the case of a lifetime. The matter presented us with an opportunity to really correct a severe abuse of the legal system. Our representation in that matter encompasses a case in state court to vacate the adoption order and to restore custody to our clients, and another case in federal court for damages. We have had many hearings in these cases, including more than 10 days of evidentiary hearings, and we've had several trips up and back to the state and federal appellate courts. The case has given many attorneys at Hunton the opportunity to handle trial-related tasks, to brief substantive, interesting, first impression type legal issues, and to present arguments before the trial and appellate courts. More than anything, the case has given us at Hunton the opportunity to live our values and to use our unique skills as lawyers for something truly good.
On behalf of Lowenstein Sandler and our Center for the Public Interest, I want to thank the National Legal Aid and Defender Association for recognizing us with a Beacon of Justice Award. The fallibility of our justice system is no longer a well-kept secret. In the last 35 years, more than 3,500 people have been exonerated in the United States. And they've collectively lost nearly 30,000 years of their lives, incarcerated for crimes that they did not commit. To address this injustice, and help identify wrongfully convicted people in New Jersey prisons, we partnered with the Rutgers Innocence Project to identify appropriate cases for potential exoneration. Our lawyers were trained on the various causes of wrongful convictions, like junk science, uncorroborated eyewitness testimony, and false confessions, and then reviewed documents, investigated claims, and prepared memos detailing the plausibility of innocence. But there are also people who, although not innocent, should not be in prison, because they've served sentences far longer than appropriate. Our firm is committed to helping individuals seek second chances through clemency, particularly when they committed a crime as a young person, received harsh sentences, and demonstrated rehabilitation while incarcerated. Lowenstein Sandler has worked with the ACLU of New Jersey to file clemency petitions for individuals who qualify for expedited consideration under an executive order issued by Governor Murphy in 2024. If granted clemency, our clients will finally be able to re-enter society, reunite with their families, and demonstrate their rehabilitation outside of prison walls.
Participating in the firm's pro bono domestic violence program is one of the greatest privileges of my career. There is something so rewarding about representing survivors and helping them advocate for themselves to stay safe from their abusers. Getting to watch my clients go on to lead successful lives after their trauma is incredibly inspiring. I would be doing this work with or without any recognition, but I'm grateful that the firm is receiving some for this important program.
Lowenstein Sandler has been representing tenants in eviction proceedings for more than a decade. Actually, for way more than a decade. We started sending lawyers to the housing unit of a local legal services agency for 4 to 6 month stints, probably 30 years ago. Then during the COVID-19 pandemic, we worked with our legal services partners to bring together the lawyers and activists representing tenants around the state of New Jersey, because we wanted to talk about how our tenant clients were going to face a possible onslaught of evictions when they couldn't pay the rent because they were losing their jobs and their incomes. We took many steps during the pandemic to prevent mass eviction, and the coalition that was created then has been meeting every week or every other week ever since. Most recently, we worked together on a report released in 2024 that shows that about 70% of the eviction complaints filed in New Jersey are defective on their face and should never have been filed, let alone adjudicated. But in fact, the courts issue thousands of eviction judgments every year based on these kinds of defective filings. In response to the publication of the report, the court has issued a new revised complaint that's clearer and more comprehensive, and the coalition is now commenting on that complaint. We'll continue to work with the courts to try to ensure that no tenant loses their home based on a defective eviction filing. 97% of tenants in New Jersey have no lawyer when they go to eviction court, and it's particularly on behalf of these self-represented litigants that we hope our advocacy is successful.
It's an honor to be recognized again by NLADA for our firm's commitment to pro bono. This past year, hundreds of attorneys and staff across the firm dedicated pro bono time to advocating for vulnerable individuals, families, and communities. Their tireless efforts fighting for civil and human rights reflect our firm's deep commitment to pro bono service and our pursuit of a more equitable legal system.
During the COVID-19 pandemic, the Boston Public Schools had to revisit their admissions criteria for the highly selective schools known as the exam schools, because they couldn't administer the standardized entrance exam. The school committee adopted an interim plan that used a combination of GPA and zip code for admissions instead. A coalition of families challenged the policy, claiming that it discriminated against white and Asian students. The First Circuit's decision confirmed the constitutionality of race-neutral policies designed to facilitate equitable access.
Last year, I had the opportunity to work with a survivor of childhood sexual abuse on an appeal to the Massachusetts Appeals Court. We were able to secure a rare 25-year protection order from her abuser, which will allow this survivor to heal without the constant threat of relitigating the protection order and reliving her trauma each year.
Domestic and intimate partner violence takes place far too frequently and is talked about far too infrequently. There are so many who suffer every day behind closed doors, but when given the opportunity to find full and fair access to the justice system, they're able to tell their stories, show their strength and resilience, and advocate for themselves. It's been a privilege over the past year to support 4 clients on that journey, some of whom have sought legal protection from their abusers and others who have fled the abuse they suffered in their home countries. Having the opportunity to work on those cases has shown me that Mintz shares the value that every person has the right to be free from the threat of domestic or intimate partner abuse. And while there is much to do in the coming years, I'm proud of Mintz's continued efforts to help survivors secure the relief they deserve.
At Mintz, we believe every lawyer has a responsibility to use their skills to expand access to justice and serve those who need it most.
The plaintiffs in this case are older adults and adults with disabilities who need long-term care services and are eligible to receive those services in their homes through the CFI Medicaid waiver. Hundreds of these participants, or even thousands of them, are at risk of unnecessary institutionalization because of the state's failure to deliver the services it has assessed them to need.
Nixon Peabody has made a substantial financial commitment. It costs a lot of money to litigate in class actions. There's a lot of expert witnesses, and we're working with nonprofit partners that do not otherwise have the resources and technology to litigate a class of this scale. I hope that my work with the Nixon Peabody team can make a positive change for the community in New Hampshire so that they too can have equality and justice.
The right to live as we choose is paramount for older adults and people with disabilities throughout the nation. The Americans with Disabilities Act, the Medicaid Act, and the due process provisions of the United States Constitution require the state of New Hampshire to properly administer this waiver program and guarantee similar protections for older adults and those with disabilities nationwide.
Pro bono is a big part of who we are at Patterson, Belknap, Webb, and Tyler. Our pro bono program addresses a wide range of legal issues and practice areas. We're proud in our commitment to helping families, communities, and underrepresented groups achieve justice. We are especially proud of our work on behalf of 3 detainees at the Abu Ghraib prison in Iraq, brave men who suffered abuse and torture at the hands of American military and military contractors who put their faith in us. We spent over 10 years litigating this case, including 2 trials and over 22,000 hours of pro bono service.
This case is about accountability for the defendant, a private U.S. corporation called Khaki International, whose employees conspired with military personnel to torture and abuse the detainees there, to get them to talk and to soften them up for interrogations.
We brought claims on behalf of our 3 clients under the Alien Tort Statute for claims of torture and also cruel and humanly degrading treatment. Our clients prevailed and ultimately received $42 million in both compensatory and punitive damages.
This case is the first time that any government contractor has been held liable for the abuse that occurred at Abu Ghraib. It's the first time that any Iraqi who was tortured at Abu Ghraib has been able to succeed in a lawsuit in an American court.
This case has helped remind me personally and professionally about just how remarkable the U.S. system can be.
You know, these people's lives were altered forever by what happened to them. It's what they went through is unimaginable. And from the moment I met them, I just felt this duty.
It's just incredible that through, sort of the pro bono work that our firm and the other honorees do, we're able to help tell the stories for them that they wouldn't be able to tell on their own.
I think the impact of this case is best captured by a quote that our client provided the day of the verdict when he said, "This victory is a shining light for everyone who has been oppressed." Thank you on behalf of Patterson, Belknap, Webb, and Tyler to the NLADA for recognizing our work and bestowing this award upon us. We'd also like to extend our heartfelt congratulations to this evening's other award winners.
Hi. Since the beginning of 2025, Squire Patton Boggs initiated a formal pro bono partnership with the LeBron James Family Foundation and the I Promise School in Akron, Ohio. Since 2018, the LeBron James Family Foundation has operated the I Promise School in connection with Akron Public Schools to serve the lowest socioeconomic population in Akron, Ohio, serving approximately 500 students between the grades 3 through 8. What Squire Patton Boggs does is we provide pro bono legal services to that population.
Squire has a team of more than 25 attorneys, paralegals, and staff who have volunteered their time to take on pro bono matters for the I Promise families. We have handled a wide variety of legal issues, including expungement matters, child support matters, landlord-tenant and housing issues, and estate planning.
Every week, we host office hours at the I Promise School where we interact with our pro bono clients and also the students of the school.
Squire Patton Boggs is so excited to have this ongoing partnership with the Veritas Debate Institute. The Veritas Debate Institute is a flagship program of the Veritas School of Social Sciences, offering a one-year introductory experience for scholars in the metro Atlanta area. The program then culminates in a summer residential session at Harvard University, where the Veritas scholars engage in a 2-week academic experience and compete in an international debate competition. Since the beginning of the Veritas Debate Institute, these scholars have won that same debate competition 7 years in a row. Squire's role in all of this is to provide the ongoing legal services that are required to not only support these programs, and in particular the Veritas Debate Institute program, but to grow that program.
Hi, I'm Nika Cohen, a senior attorney with the Public Service Initiative. I was part of a pro bono team that had the honor of representing a client in the DC Superior Court under the Incarceration Reduction Amendment Act, which creates a sentence reduction mechanism for young offenders who meet certain criteria. At just 24 years old, our client received a 60-year sentence for his involvement in the tragic murder of another man. In June 2024, our pro bono team presented in court the evidence of our client's remarkable transformation over the past 2 decades, during which time he'd become a role model and mentor to many young men in prison and completed thousands of hours of programming and education. After hearing this evidence, the court ordered our client's immediate release from the bench. Several days later, our client's family was able to welcome him home. In the years since, our client has excelled in every way, including graduating from the Georgetown University Pivot program. We were honored to represent our client and to do so on a pro bono basis.
Steptoe is honored to be recognized for our work on behalf of families facing homelessness, navigating the special education system, and planning for shifts in child custody and support. Pro bono is an integral part of our firm's history, ethos, and operations. This recognition is a testament to our long-standing commitment to representing families in crisis, supporting community justice efforts, and empowering vulnerable populations. We remain steadfast in our mission to provide legal support to those most in need. Thank you, NLADA, for being a beacon of leadership in doing this important work.
It was early 2024 when we started seeing referrals of individuals from Liberia, from Guinea, and pretty soon we were flooded with individuals. Almost every one of them had what I would consider an objectively strong claim for asylum. But even at a place like Stinson, where we have a culture of pro bono and we have the legal clinic through which a lot of our attorneys and timekeepers get involved, I knew that we wouldn't have capacity to take on 100 plus asylum matters. We were able to launch this clinic to help folks get these applications filed. And it really is due to the unique nature of our legal clinic that I think we were so successful with this, because we leaned heavily on some amazing people at Cook, at the medical clinic. These are folks who have fled some of the most horrific things you could imagine. Trust is really hard to gain. So having that hosted at our clinic, at our clinic, which is at Cook, was extremely helpful, because that's one place for them that they feel safe and that they trust. Yeah.
Like there was one where, he described how he'd been beaten several times, and so I asked him, could you show me your scars? And so he takes his shirt off and shows me his scars that went up all the back of his head and down his back and his arm. And then the interpreter was, I believe, a Malinka interpreter, and she said, that's the first time he's shown anyone his scars. It was just being able to create an environment where he felt comfortable.
I think when communities come together, they can build a better community and a better world. Because that's what I see us doing here, right? Is we're working together to bring these people to our community, right? And to give them a safe place to stay in our community, that they can grow and flourish and improve our community. That's really the whole basis of why we do what we do.
Service to our community is the touchstone of Wiley's Pro Bono program, and we are deeply honored to receive a Beacon of Justice Award from NLADA in recognition of our impactful and life-changing pro bono work. Like NLADA, Wiley aims to advance equal justice for all and deliver excellent legal services to those who cannot afford counsel.
In the past year, Wiley has performed a wide array of work to obtain justice for families and communities through securing victory in the U.S. Supreme Court in a precedent-setting double jeopardy case, successfully challenging unconstitutional censorship in North Carolina state prisons, defending the constitutional rights of incarcerated individuals in a Virginia correctional facility to appropriate medical care, persuading the Supreme Court to hear an important case addressing the public benefits due to our military reservists and their families, and obtaining a civil protection order for a survivor of domestic abuse.
Thank you to NLADA for recognizing the important work that our attorneys have done on behalf of families and communities, both here in DC and around the country. We look forward to continuing to make an impact through pro bono service.
Hello, everyone. So great to be here with you tonight, both on your screen and hopefully in person. Wilson Sonsini is honored to receive the Beacon of Justice Award once again for 2025 and to be recognized by NLADA as a firm that is dedicated to families and communities through our pro bono work and community service. This recognition is so meaningful to us given the outstanding work of our fellow nominees. Y'all are inspiring, as well as NLADA's distinguished legacy devoted to excellence in the delivery of legal services to those in need. Simply put, NLADA is a true pioneer and leader in service to the vulnerable and in providing access to justice for all. For Wilson Sonsini, a few examples of our most recent work include representing farmers in pursuit of equality, representing courageous trafficking and domestic violence survivors, and supporting numerous nonprofits and social enterprises that support countless communities across this great nation and beyond. We also support communities with food drives and sorts, support for youth and families, disaster relief, and particularly fun projects I love, such as building playhouses for children of those who serve, including families of first responders and military families. In sum, we are so proud and honored to stand shoulder to shoulder with our awesome clients and beloved communities, and with NLADA and everyone here tonight in dedication and celebration of service to families and communities. Thank you so much, and a great eve to all.
Zuckerman-Spader is honored to receive NLADA's 2025 Beacon of Justice Award. In 2024, we advocated on behalf of clients who might otherwise go unheard and helped deliver real change. Among the impactful work we handled last year are cases addressing food insecurity, access to public records, and housing rights.
In DC, families relying on the Supplemental Nutritional Assistance Program were being denied a promised 10% funding increase. This funding increase was mandated by law passed by the DC Council, but the mayor refused to implement the increase. We mounted a compelling argument and informed the mayor's office that we intended to file suit. This pressure led to the mayor reversing course the next day. This was an important food security victory for thousands of families, children, and seniors in DC who depend on the program. My colleague Samantha Cavanaugh led another successful effort to protect a different vulnerable population in her state.
Government transparency in a precedent-setting case in Maryland. In Calvert County, Maryland, the sheriff's office tried to block access to public records about invasive policing by denying the public interest nature of these types of records and attempting to charge more than $12,000 for them. On behalf of a civil rights organization, we sued the sheriff's office, received 2 favorable rulings in court, and ultimately negotiated a settlement that resulted in the release of the records and the payment of our clients' legal fees. This important victory dismantles obstacles to seeking clarity on law enforcement activity. My New York-based colleague, Ariella Muller, worked closely with one of our partners to protect their clients' constitutional rights in an important housing case.
In Baltimore, our clients lost everything they owned, including family photos and loved ones' cremated remains, due to a city ordinance that deemed personal property abandoned at the time of eviction. Our client's landlord used this ordinance to wrongly seize all of their personal belongings. After trial, we secured $186,000 in damages for our clients and a ruling that affirms due process for renters. The city appealed, and we handled that appeal pro bono, and the Fourth Circuit affirmed. This case is now fueling statewide reform efforts.
Thank you, NLADA, for acknowledging these efforts and your ongoing commitment to improving our communities.
Congratulations to the winners of the 2025 Beacon of Justice Awards. Your tireless efforts to uphold civil and human rights inspire us all.